in going for
Calcutta bench.
this bench.
Yes, single bench. Yes.
There is an urgency where we are entering the compromise with the respondent about 25%. We also want the matter to be taken out today so that we get order of peace will be fast.
Is it compoundable?
Well,
What
the new act.
offenses?
For 409 is.
Then?
That means we are relying upon. Because we are coming with the settlement terms. We are entering to.
They're offering us a settlement, my lordships. So on the basis of that settlement only, we are actually trying to reach a compromise. And the only problem is that the clients are based on a foreign jurisdiction. So we have to get the authority under apostolition in order to have the MOU executed. So under that circumstances, if it could be, if we can be accommodated, my lords, I'm sorry,
You are the private opposite party.
my lords, my
Who's
lords.
appealing for the administration? You need to serve the administration
I
also.
will take this up. But now, my lords, on basis of
Can you
this.
do this by today? It's a Saturday, that's when.
Yeah, it's a
Yes,
Saturday.
Can you serve the administration? But let me fix it at 12 o'clock in that case.
Please.
My lord,
Serve the
my lordship.
administration. Come
I
back.
will try to get them out. Yes, that's the not also not my.
Because in absence of the administration, it cannot be dealt with.
Yes.
Right?
The effect of complainant is coming forward, not stating that we are entering to a compromise.
I understand, but it's a state case.
We have to, we'll serve them, right?
The
Simple.
administration has to be there.
My lords, may kindly keep it at 12 o'clock. We'll serve them with the best of the possibilities.
Supplementary.
Deeply grateful.
Mentioning to me supplementary.
Much obliged, my lords.
Yes.
What happened at number 1, that is 1925.
Who's appearing?
My lord, I am appearing for the petitioner, my lord, Union of India.
The application is allowed. I'll read out the operating part. In our considered view, the tribunal ought to have decided the matter on merits in terms of the order of this court dated November 11, 2024, and disposed of the application upon granting reasonable opportunity of hearing to both the parties. The tribunal not having acted in terms of the direction of this court, the order impugned is required to be set aside. The order is set aside. The respondent shall be at liberty to seek interim relief during pendency of the hearing before the tribunal.
My
Thanks.
Next.
Here it is of 24 number 3, here it is 24.
Lordship, I am appearing for the state. One appeal is filed by the state, one is by the victim.
How can appeal be fixed on Wednesday? How can we deal with it? Let us shift it to the next subject. You're the appellant.
Let it be, Lordship.
I not kept it on Saturday, I've come very far.
Right, I understand. Thank you for that. I mean, so that we could deal with it because we have lesser matters today, so you missed a chance. Anyway, on prayer of you're the private.
Respondent, the sole respondent.
Cannot be sold because the state is there.
No, they have also appealed, madam. They have preferred an appeal. Two appeal.
The magistrate,
The state has filed one appeal and victim has filed one appeal.
How many witnesses? One is for compensation, one is for enhancement, right?
No, this is acquittal.
Acquittal.
Clean
Oh.
acquittal.
The state has preferred an appeal against the acquittal, madam, and the victim will also prefer.
How many witnesses are there?
The matter is such that out of the total witnesses, there are 27 witnesses.
27.
Out of whom we would need about 18.
Next, I don't know.
Because there is a
We were wondering whether it's a short matter.
there is a substantial amount of material because this is rape, abortion, those parts.
On prayer of the respondent, the matter be placed before the next available circuit. Matters be placed.
Obliged, Lord.
Item number 455 of three.
For the appellant. I don't find my counterpart to speak.
Where is the respondent?
Mr. Khan is for the respondent.
Not seen today.
I filed my reply also to a CAN application. They filed opposition. The last occasion, I filed a reply to the CAN application.
Is it a short matter?
Divorce you are granted by the family court. I filed application order 41 to 27 for giving additional evidence.
That is the application pending.
Yes, the application is pending. That is pending. My application under order 41.
27 application has been disposed of.
No, no, it's pending, still pending.
There's a can.
That's the CAN. That's the CAN.
When will you come back today? I do not find.
Monday, I'm ready. I filed reply.
Monday, what is it? Hmm. Under 13, yeah, everything. 13 matters. We are used to 200 matters in a list. None appears for the respondent. The matter is adjourned for the day. That takes us to Monday.
I'm good.
day after tomorrow is Monday, we not even a Saturday.
Case diary may be called for, your lordship,
Yes.
so that on Monday at least,
Please inform in that.
I will inform. I think,
Direct.
Mr. Shatabdru is appearing. Okay.
No.
Item number 3, my lord, I'm appearing. Item 3, I'm appearing.
The state is not represented. The
No,
matter.
I'm appearing item 3. And item 3, I'm appearing.
Item number 1, Lordship, I am appearing, let it be on Monday, I will call the CD, Lordship. CD may kindly be called for.
The learned counsel, delete that. Learned counsel for the state seeks accommodation. Let the matter appear under the same heading on 4th August. Case diary be called for.
Your lordship.
Obliged.
Item number 2.
Lord, I'm for the petitioner.
I am for the respondent, my lord.
Lord, it can be disposed of. Lord,
No, my lord, it is a money claim and serious disputed of X and claims are there.
I just-
So remedy lies before the civil court. I can give the reply. My lord, this is the reply given to by the bank to the petitioner. Kindly see the reply. Yes.
Lord, the petitioner has been awarded with the work in terms to the maintenance of the Canara Bank with regard to sound, this alarm system and other computer service and all. Yes, performed. After the completion of the tender period, further they have extended for 3 months. That period also we have performed, we have raised the bills of payment. Thereafter, they have not floated a new tender, and it has to be as an essential service of the public. So they told us to give service. We have provided service. And before service, they have made a payment. But with regard to the materials, as because we have to supply the fire extinguishers also, we have to refill the fire extinguishers, that all the tender terms and conditions. We have performed, we raised bills. That bills are pending. We for several occasions, even 2-3 legal notices have been issued. At least I don't know why the bills are not been honored. The reason should be communicated to me. Nothing has been done. Lord. Then as the mail, they said you send a
They have replied in the mail. Kindly see the mail. And they have not annexed these mails.
You've replied to the mail. You've replied to the mail.
Mail, yes, my lord, we have. This is the mail
Yes.
dated 25th February 2025. Our question is that the rate of refilling ABC fire extinguisher is 2360 including GST as per extinguisher per extinguisher. But you have quoted rupees 2780 84.80 including GST, that too per kg. Amounts would be 9,440 and you have quoted 44,556. Dispute. Amount.
That figures quoted by you.
They have more than the.
What I suggest, Lord, let them consider what is the admission amount they can release. If I
No, no.
That we should have
Yes.
accepted them.
that can be released, Lord, that is not released.
No, but they have not, apparently, so the second one, you have, the second one, you have delivered new CO's extinguisher at our Rangat branch. As per the approved rate is 9,000 plus GST per extinguisher, but you have quoted per kg excluding GST.
So
Yes.
the item, you say that it's an inflated quotation, right? So I have a suggestion. Let this matter be dealt with by way of mediation.
No, that can be.
Well,
Lord,
Because
can
this
be-
is only a money claim.
Yes,
Appear before the mediator, talk to each other, settle the claim.
Lord,
This
my lord.
did not be continued for days together.
that's.
But we have written also, kindly see the next mail. With reference to your trailing mail, it is to inform you that your bills have been returned. You are requested to resubmit the corrected bills. It's dated 16 June 2025.
Lord, may kindly see the annexed 216 once, Lord. If that will be clear, the issues, everything. If that
Do
be.
you agree to the mediation? Let
Yes,
us-
I agree, but their
Yes, ma'am.
submission they have made, that is contrary to the records.
No, no.
Can come to 16 once.
No, he is reading out the,
Then
Yes.
after that mail, last one is in 2nd July 2025,
200?
216 of the petition, 216. With
Yes.
reference to the email training below, with the due respect, our firm has already submitted invoice containing, because they told me to submit a fresh invoice. I have made all the invoice. Again, I have been scanned and sent to them.
No, again, they have sent the same bill, my lord.
This
They have
is
not corrected
letter.
it. They have
This is
not corrected.
letter.
They are saying that we have corrected.
Since-
They say that our bill was right.
Since there are no factual disputes as such, it is only.
If factual disputes are there, my lord.
Lord, the admission amount.
I said,
Please,
no, no.
what is it? What is the not agreed about? They are not saying we are not.
They have-
Settled with the mediator, it will be done in a.
My lord.
the primary cause for filing the writ application is that despite completion of work by the petitioners, the respondent authorities have not cleared their payments. Paragraph, learned counsel for the respondent authorities submits that the petitioners have submitted inflated bills which have been returned to the petitioners for submission of proper bills in terms of the approved rate in agreement. Paragraph. Learned counsels for both the parties concede to the suggestion of this court that the matter may be sent for mediation. Paragraph, in view of the above, who is the mediating committee here? The SLSA. SLSA does. Let me tell the registrar to take necessary steps. In view of the above, the learned registrar, Calcutta, is directed to take necessary steps for sending the matter for mediation. Mediation will take 60 days.
Within next circle, it can be done.
It's a local level, it's not a mediation. So let the next bench go in for local, because both have to be done simultaneously, mediation and. Let me say from here, let the next bench start. We have to divide to remains. Local, I've already sent information from the next one. Yes. Mediation is, let it be before the next.
Yes, in the meantime, mediation.
The matter be placed before the next available circuit bench. Please impress upon your respective.
Yes,
courts,
yes,
it should take a day.
But I surrendered my service. They are not denying that I am not done.
They have committed fraud. They have submitted false claim.
Quotations of.
That is approved, right, which is in the contract.
No.
That has been based
We
on
have-
bill. They could have
we have-
clarified.
They have
Nothing has been
clarified it.
done.
They have not changed the bill. They say that.
Yes, yes.
Yes, sir.
Obliged.
Obliged.
Item number 3.
My Lord, I beg to appear for the respondent, my lord, in this matter with Mr. Rakesh.
Your Lordship, I may be permitted, Your Lordship, my junior will make the submission, Your Lordship, related to that. And if it is required, Your Lordship, I will.
If my learned friend can please speak
You have to
the
yield.
mic, my lord, I am not able to hear. If he can please speak into the mic.
Herein has approached this honorable court seeking quashing of the notices of assessment of tax due and assessment of penalty. Your Lordship, the petitioner herein has invoked writ jurisdiction due to the reason that the commissioner has exceeded his jurisdiction by making an assessment. And secondly, he has not provided any opportunity of hearing. What has happened, Your Lordship? When the GST Act was introduced in 2017, all the taxation came into a particular framework. But there were certain products which were excluded from GST, such as alcohol and petroleum products. What happened is, for alcohol-related products and petroleum products earlier, there were octroi bylaws. These octroi bylaws were repealed and a new value-added tax regulation was framed and it came in 2017. When the regulation came in 2017, it could not be brought into full-fledged operation due to the reason that the regulation provided certain definitions which were undefined. Because the regulation said that when the rules will be framed, the manner of filing the tax returns, when the tax return has to be filed, that will be cleared when the rules come in. The rules came in the year 2020. Now, Your Lordship, the basic concern here is with regard to certain provisions of the regulation, which I would be permitted to explain. Your Lordship, section 26 of the regulation deals with the thing that a dealer who is registered under this value-added tax regulation, he has to file returns. Under section 30, the commissioner, the value-added tax commissioner has got the authority to carry out assessment. Section 32 says that when the dealer has filed his returns, the commissioner may, after assessing the returns through the best of his judgment, he will assess what is the tax due. Section 33 states that if at all the commissioner finds that he has a reason to for imposing a penalty, he might impose penalty. Both section 32 and 33 have to be read together with section 58, which says audit. Before making an assessment under section 32 and section 33, there has to be an audit carried out under section 58 of the regulation. In this instant case, there was no audit carried out. This is a notion of opportunity of hearing. Secondly, Your Lordship, section 34 says that whenever an assessment has to be made, it has to be made within 4 years from the end of the financial year. For example, for financial year 2019-2020, the assessment time limit is for 2024, March 2024. But in my case, for the financial year 2017-18, 18-19, and 19-20, the assessment notices were issued in December 2024, which itself is time bar. Now, when the time limit has been exceeded, that means the commissioner has gone beyond his jurisdiction. And this notion has been dealt by Division Bench of Bombay High Court, wherein the reason is the Bombay High Court therein dealt with the value-added tax regulation in Daman and Diu. Here, this is Andaman and Nicobar Islands. Both are union territories. The tax regulations are same. Both union territories follow the same value-added tax regulation. The difference is the state name changes. Therein also, the Bombay High Court has held that as the commissioner therein had exceeded his jurisdiction by crossing the time limit, then the notices have to be quashed. But before approaching this court, the dealer herein had approached this court as well by a writ petition. But what has happened there, at that time, the dealer had already submitted a representation to the commissioner that he will be filing objection as per section 74 of the regulation. So this Honorable High Court has said that as you are already intending to file an objection, you go and all the points are kept open. So the dealer herein went to the value-added tax commissioner. He filed an objection. After filing the objection, he raised all the issues with regard to jurisdiction, with regard to opportunity of hearing, and also the merits. After that, an order was passed on 22nd of July. On 22nd of July, wherein the objection was rejected. The objection filed by the petitioner herein was rejected. That is impugned, as well as the notices under 32 and 33 is impugned. Now, Your Lordship, the thing here that has to be considered is whether the dealer herein has to approach appellate tribunal or not. Appellate tribunal has not been constituted yet. There is no relief available for the petitioner hearing other than to approach this honorable court. And secondly, the Bombay High Court has dealt with the notion that when the commissioner has exceeded the jurisdiction, in that case, whether the alternative remedy available to approach appellate tribunal has to be dealt with or not. When the commissioner has exceeded jurisdiction, the petitioner need not approach the appellate tribunal because the petitioner can approach Honorable High Court under writ jurisdiction. Secondly, Your Lordship, the notion of auditing. What has happened in the previous writ petition is that the respondents have claimed that audit is not at all required. But Bombay High Court has said that section 15 audit should not be read alone. It has to be read along with 32 and 33. I can read the sections. Now what has happened is, in this honorable court, in the division bench, in the case of Jharna Saha, has held that when an opportunity of hearing has not been given, that is audit in this case, in that case, the assessment becomes non-exist in the eye of law. Therein, the appellate tribunal had allowed the contention of the petitioners, but the appellate tribunal has redirected the petitioners to the appellate tribunal for reassessment. But the division bench of the Honorable Calcutta High Court has held that reassessment is also required because the assessment itself is non-exist in the eye of law. So, under this thing, I have approached this Honorable Court, Your Lordship.
So if the assessment is non-est,
Your Lordship.
a further assessment is required, right?
Your Lordship, that has become time barred now. That is what the division bench of this Honorable High Court has held.
So can the person get away without paying taxes at all?
Your Lordship, with regard to that, what I would like to submit is, it is not denied by the respondents that we have not paid taxes. The thing is, they are saying we have not paid the taxes in the format they intended to. The reason is, Your Lordship, in the year 2017, the tax regulation was framed. The definition of tax period was under section 2(1)ZG, subsection 1, subsection ZG of the regulation. In that, the tax period was defined as when the rules will be framed, the definition of tax period will be clear. Rules were framed in 2020. How can retrospectively the petitioner be made to act as per the rules? for the period 2017-18, and when it has already become time barred, because your lordship, this is not a beneficial legislation. It has to be correctly construed, strictly construed. And your lordship, in the objection which was rejected by the respondent authorities, they have stated that we have also raised the point of section 34, that is, it is time barred. What they have stated is, they have interpreted section 34 saying that if this will be construed as it is, then the purpose of this regulation will get defeated. But your lordship, in that manner, then the Bombay High Court division bench has no value. That judgment was placed before the value added tax commissioner, your lordship. The impugned
Is
order,
it part of your petition?
your lordship. Judgment I would submit, your lordship, but the written notes wherein I appeared before the value added tax commissioner incorporated both the judgments, your lordship.
And that's part of your petition?
Your lordship, I have not mentioned the judgment in the writ petition, but I have mentioned the factual notion therein. But it is a part of the written notes which I have annexed with the writ petition. I will be allowed to place the judgment, your lordship. The last page.
Do you have a copy of this judgment?
I'll be providing the
So
copy.
judgment copy, I don't, but let him place it, my lord. I will gather
Yes.
from our submissions.
And these are all legal points basically, so you don't want to come back with an affidavit, I think.
No, I want to come back with an affidavit because according to me, my lord, the point of jurisdiction is completely misplaced because assessment and according to us, the assessment and audit are two different provisions altogether. We would like to file an affidavit, but only thing is, my lord, if the impugned order, which is very detailed, my lord will see the only operative part is the authority has said that within 15 days they have to make payment. But my lord, if they don't make payment, it is recovery proceedings are long drawn. So it is not as if anything is going to happen overnight. So if my lord grants us 2 weeks time, my lord, we can come back. And of course, if they liberty may be granted to them, if necessary to seek orders, my lords. But at this point of time, if my lord is called upon to grant interim order, then my lord, we would have to argue, my lord, because that would be an expression of opinion by your lordships on the merits of the case.
Operative part.
The order
The
is in page number.
order impugned is 157. It begins, and if my lord sees the operative part is at page 160. So only thing is last paragraph, the authority has said petitioner shall discharge their liabilities within 15 days of service of this order. Now this order is dated 22nd July 25. I don't know when they have received a copy, must be a couple of days later. So in any case, they have only, as long as when the matter is pending in the court, I don't think authority is going to do anything like that.
Granting a short stay of this order?
No, my lord, that will be difficult because in our humble, we will have to then, my lord, try to satisfy your lordship that no case is made out. All that I'm saying is, if a short time is granted, even 7 days.
This circuit will not be there then. So let there be a very short stay till 31st August, till the next circuit starts.
My lord, my humble submission is, my lord, if my lord's prerogative, but I am only making a submission, my lord, for your lordship's consideration. This order only says that the petitioner shall discharge liabilities within 15 days. Now, if in a situation, if there was no court proceeding also, if the petitioner did not discharge the liabilities, then proceedings for recovery would have to be initiated, my lord. All of this takes time. It doesn't happen nothing is going to happen in 2 weeks, my lord. So my submission is.
When this court is in session of the matter, why will unnecessarily proceedings be initiated for non-payment?
That is exactly what I'm submitting, my lord. Proceedings would not be initiated. But if my lord expresses an grant stay, that would be an expression of opinion by the court that there is a prima facie case made up.
Without going into merits at all. Since the court is in session, I'll grant a short stay.
My lord.
Right?
But my lord may say that my lord has not gone into the merits, my lord.
Yes.
Request.
I'll state. The petitioner is agreed by the order passed by the Joint Commissioner within bracket VAT on 22nd July 2025. Directing the petitioner to discharge his liabilities within 15 days of service of the order, comma, primarily on the ground that the notices of assessment issued under sections 32 and 33 of the regulations are valid. Paragraph, learned counsel for the, no, not this, please strike it up. The respondents seek to use an affidavit in opposition in this matter. Paragraph, affidavit in opposition be filed within 2 weeks. Within 2 weeks from date, in another week.
Your Lordship.
Reply, comma, if any, comma, affidavit and reply, comma, if any, comma, be filed within a week thereafter. Paragraph, since this court is in session of the matter, comma, let there be an interim stay of the order impugned till 31st August 2025 or until further orders, comma, whichever is earlier. Paragraph, it is made clear that this court has not gone into the merits of the case and the matter shall be decided on merits upon exchange of evidence.
Your Lordship.
Mine. Most
Okay.
good.
Monday.
Next,
Item number 4, WPS 348.35.
yes.
I am appearing for the petitioner, Your Lordship. The issue herein is with regard to the issuance of transfer certificate in favor of the minor.
He's appearing for the,
The affidavit of service has already been filed, Your Lordship. Both the respondents have been served. That is the principal and the husband of the petitioner number 2. That is the father of the minor. Your Lordship, I pray that this be fixed on Tuesday because the petitioner herein has intimated me that after receiving this notice, the school authorities have contacted her for
Issuance.
probably
For
they might
issuance.
issue on Monday.
Very.
So I pray that this be fixed on
Will it be
Tuesday.
Tuesday or Wednesday? Do you need another day's time?
Your Lordship, let this be appear on
Wednesday?
Wednesday, Your Lordship.
Because if
Wednesday.
it's cleared on Monday, then
Your
you
Lordship,
can come
Your
back and withdraw this.
Your Lordship.
None appears for the respondents. Where is your affidavit of service? Sir? Now, affidavit of service filed by the petitioner is taken on record first time. Huh? None appears for the respondents despite service. Paragraph, let the matter appear under the same heading on Tuesday, 6th, 6th, Wednesday,
Your Lordship. Obliged.
6th August.
Sir, I am appearing for respondent number 1.
In this matter,
Yes, sir.
learned counsel says that the school has
Yes.
called the petitioner.
Yes.
So let us see what happens in
Yes.
this time.
Obliged.
Item number 5, WPS 355.
I appear for the petitioner, Your Lordship. Yesterday, my learned sister, she was asked to bring the records. This is with regard to that Tehsildar, Your Lordship, who has passed the order, impugned order without giving any opportunity of hearing.
Yes, yes.
And he has passed an order for demolition of my wall,
And she said that opportunity was granted.
was granted.
Where,
Yes.
where is the law?
My lords, one private respondent is also there, and in the absence of the private respondent, I don't think.
No, I have already served. She has received it by,
So, my lord,
that acknowledgement is there.
the endorsement of the mother of the petitioner is there in the notice.
And mother doesn't stay with me.
Records, those records are with me, and I can show that.
Please show me the
mother-
service.
My.
Yesterday's service about the private respondent was not
Oh,
complete.
it is done. Today only we have served the affidavit of service.
You have that it?
Yes, I have. She has received by her own. Signature is appeared. Fine. Good है लग करके देख कौन सा है बताओ
The bottom portion was received signature. Another notice is also there, not the hard pack.
So whose signature is this?
My lord, why I'm saying so, that the signature is of Madam. Another notice I can show, my lord, where it is written, she has written the timing also, and mother of the.
Where is that
It
notice?
is also there.
The other flat one?
Yes, yellow one.
This is much prior. This is 18th September 2024.
Mine.
Does it bear the same RC number?
This is our, no, this is an order.
Then
Yes, because the signature, to see the signature is of the mother of the writ petitioner.
might have been given. I am not
So that
denying,
is-
might have been given, but I am not aware.
That signature is of mother of the writ petitioner.
So you were put on notice.
No, your lordship, because
Yes.
my mother stays at a different place, I stay at a different place. When it has not been served to me, my mother, she's an old age lady and she's already suffering from many diseases. She has not informed me.
That cannot be a ground.
No, I am not aware, lordship. Why will I file such an affidavit?
Purely aware of this matter.
It
Lord,
was
that
served
on
at
the
your
basis
mother's,
of a
at your
complaint.
address, not at your mother's address.
Why it was served to my mother then? It would also have been served.
She was there. At the
No, she's not staying with me. Why will I
Maybe
lie
she was
here?
there at that time.
She was there, maybe in her house.
Where is the address at which it was served?
South Point.
Some Point is a big area. Here the question is not only serving this notice, your lordship. When the field inspection was done, even that notice was not given to me. When you conduct this field inspection, will you not serve me any notice? Unilaterally passing an order that I have encroached the road area, whereas, let me complete first. This road is existing from past 3 decades. The road is existing in the same position. And your lordship will find from the report of the field inspector, he has stated that he has to take assistance of revenue survey. He is not sure. If your lordship may kindly go through the report which was filed by the field inspection report. There it is. It is very much.
That report?
It is there in the record. I have just seen. He says that revenue survey's assistance is required. Without taking assistance for revenue survey, unilaterally that I am required to demolish a wall which was constructed way back in the year 1980. It is just because I have a very bad neighbor that this is happening with me. And not only me, there are several other persons who are staying. This road was not narrowed by me. And where is the document to show that there exists any road which is recognized road of 10 meters or 11 meters width? Absolutely, a personal grudge has been imposed. The private respondent is a person lady, she has been complaining not against me, but all other residents also. And I should be given an opportunity, fair opportunity of hearing. Within no time, your lordship may kindly see, within a week or 10 days, they have given me to demolish my old constructed wall.
A revenue field staff had held an inquiry.
Yes.
Field inquiry. Where is, do you have the report?
Yes,
Was it in presence of?
even in the revenue proceeding, my lord, revenue case proceeding, the counsel for the writ petitioner was present, I can show, junior to Miss Lee. She was present. It's not that no opportunity was being given to the writ petitioner.
But, does it reflect? When they had been there, they said that we have
It's
already
not
passed the
a new
orders.
case. It's not a new case, it's like since 2018.
Lordship, I don't have the copy. Let me be given with the copy.
Even I don't have, I'm just showing it from the record.
पहले वाला नहीं, ये तो चलता ही है. This is in connection with some other proceedings, your lordship. Other proceedings, not connection with this.
Will you come back with a short report on Monday and sing these?
Monday.
I need to see all the documents, like the inquiry being held in presence of the petitioner,
Mine.
a detailed proceeding where the petitioner was represented. If you can show that the petitioner has no case.
Mine.
Proceeding should be in
I'll
accordance
just
with
show
law.
the report, Your Lordship, which was conducted by the field. Report है इसमें. इसे प्लानिंग और प्रोसीडिंग भाई कौन सा प्रोसीडिंग्स लेके आ गया प्लानिंग में. पापा भाई कौन सा प्रोसीडिंग्स लेके आ गया. ये नहीं कर सकते.
This order doesn't even say which land, which road was occupied, encroached upon.
Yes, this is the report. It will all is there.
The survey number on which the road exists, that is also not there in the order. Which road are you talking about?
This is the report, field report, which I handwritten report.
The area has not been mentioned, the village has not been mentioned.
Nothing is there. in the report.
Mine.
Here the petitioner's land survey number has been stated, not the encroached
No.
land. A hearing of both the parties may be conducted to
Resolve the dispute.
resolve the dispute, and also the width of the road and its actual position may be ascertained by the revenue survey.
Survey. There is no
After
revenue survey. No revenue survey was ever conducted.
Any further steps taken after this?
You would have to take instruction on that.
I have taken the entire certified copy of the proceeding. From here it appears nothing was done thereafter. Whole certified copy I have taken.
Let this order be set aside. Let there be a fresh proceeding altogether. Let them hold a field inquiry report in presence
The
of.
village is not mentioned in the
Nothing
order.
is there, yes. Let them hold a fresh field inquiry report, certain the portion of encroachment, if any,
Right.
and then grant opportunity of hearing to the parties.
On the basis of this report, because
Not
no,
this-
no, no,
This
fresh
report
report
has nothing. This report was also not in presence of the
Right.
parties. A survey has to be done in presence of the parties, a field inquiry. The petitioner has essayed.
my lord, if there are, because I think the power of attorney holder of the petitioner was his mother. So
Yes.
everything she used to receive, the notices and all.
Now it has
if
to be
when
served to the
we
petitioner
Conduct a
himself.
demarcation or a site inspection, if he doesn't come then.
It can be served to the council. Council
This
will
absolutely can
communicate.
be proceed because we can't wait for him to come.
So let it be petitioner or his
Because-
representative.
Or his
Since
council.
then he has made some unauthorized construction, that's why. he
Let it be
doesn't
the
come
petitioner or
in the
his
picture.
representative.
Or
My,
Right?
that.
Ensure service of notice.
Yes.
Despite that, if he doesn't come, it is
It's
his
his
call.
mother who she is receiving the notices on his behalf.
Serve the learned counsel. She's a.
I'm ready to accept.
Serve her in
Let there
for
be-
abundant precaution.
Let there be an order that we can serve the notice to the council of the.
Petitioner and the learned counsel.
My.
Serve both for abundant
Lord,
precaution, right? The petitioner has essayed the order passed by the Tehsildar, Sri Vijayapuram under section 104 of the Andaman and Nicobar Islands, LR and LRR 1966 on 25th July 2025, directing the petitioner to vacate/remove the unauthorized occupation over government land. Third learned paragraph, third learned counsels for the parties. Paragraph, learned counsel for the respondents produces documents to show that the notice of hearing was received by the petitioner's mother. Paragraph, learned counsel for the petitioner submits that the petitioner's mother does not reside with the petitioner and has not communicated the notice to him. Paragraph. I have considered the rival submission of the parties and material on record. Paragraph, it appears that the notice impugned does not bear the identification of the allegedly encroached portion of the plot. No survey number of the plot has been recorded in the order.
I mean, village. Village is also. not
No survey number or name of village has been recorded in the order. Paragraph. The order was passed on the anvil of a report submitted by,
Patwari area, Patwari area.
that is also not there.
No, the bottom.
I'll just see.
The bottom.
I mean, there is only an initial without anything else. It's only an initial.
Nothing, Your Lordship.
Was-
RI has been written down below, but
It's
revenue,
signature.
yes, signature.
Inspector.
There is
No, it is not
there
in
is
the-
RS written.
काटा हुआ.
It's some PC 7.
PC, Patwari circle.
Patwari circle.
Oh, that's Patwari.
Patwari.
Patwari circle.
Patwari circle.
Yes, repeat the numbers. It's called the Patwari circle.
Yes.
The Patwari circle -7. Because these terms are for the islands.
yes, yes.
We are not very much acquainted with these terms. Circle 7. Which records the survey number of the land belonging to the petitioner, and also that a hearing of both the parties may be conducted to resolve the dispute, and also the width of the road and its actual position may be ascertained by the revenue surveyor. Stop. There is nothing on record to suggest that such ascertainment was done by the revenue surveyor pursuant to the report. The order impugned has been passed only on the basis of such report, which does not demonstrate the survey number of the disputed path or any encroachment made therein. It is also seen that such report was prepared without granting reasonable opportunity of hearing to the parties. The petitioner was not granted an opportunity to defend his cause before the authority. Paragraph. The order impugned dated 25th July 2025 being devoid of any legal basis whatsoever, comma, is required to be set aside. Paragraph, accordingly, the application is allowed. Paragraph, the order impugned dated 25th July 2025 passed by the Tehsildar, Sri Vijayapuram is set aside. The respondent authorities are directed to deal with the complaint submitted by the private opposite party, a private respondent, upon conducting a field inquiry with regard to the allegations made therein, upon granting reasonable opportunity of hearing,
And by conducting revenue survey as well.
upon conducting inquiry / revenue survey.
Yes.
Now, upon granting reasonable opportunity of hearing to the parties / their representatives,
Or through a
comma,
learned
in
counsel.
accordance with law. Yes.
Through a learned counsel, you know.
Representative
Yes, yes,
can
yes.
also be the law. I've made
Problem
it a little wider.
Because her mother being a power of attorney holder of the writ petitioner, she used to accept all the notices and all. What we believe that,
Was the power of attorney given to the authority?
again, the
Such
representative,
notice
again,
Lordship,
they'll take this plea.
be
report.
served,
submissions have been
be
advanced.
served upon learned counsels appearing for the parties
Fine.
also. Upon holding such inquiry, comma, the Tehsildar will pass the order, the
Yes.
final order. The Tehsildar shall deal with the issue upon granting reasonable opportunity of hearing to the parties / their learned counsels in accordance with law. The entire exercise should be completed within 3 months. The survey and the hearing within 3 months from date. 3 months from the date of communication of the order.
Look, since I've not filed my affidavits.
Since no affidavit has been called for, the allegations made in the writ petition are deemed not to be admitted by the respondents.
Obliged.
Obliged. You can take back this.
Fine.
Next.
May we get back the.
Yes, I will.
Item number 6. WPS 340 of 2025.
My lord, I am
Lordship, I am appearing for the respondent, Lordship. Her application for grant for getting the electric connection is pending. Let it be disposed of within a time frame manner in accordance with law. Direction may be given to the authority,
What
Lordship.
is the prayer in this application?
Yes, my lord. The application is pending.
Domestic electric connection.
Yes, my lord.
Lordship.
When was the application filed?
18/7/2023, ma'am, my lord. Again, on 25/7/2024 is application filed by the petitioner, but
Where are the applications please shown? Nothing has been done after that.
annexure P3, my lord, page number 17, my lord. Nothing is done by the respondent authority, my lord.
We have
Again,
went to the spot, everything we have done, but why they have not disposed of this application, I do not know, Lordship. So a time limit, 2 weeks time may be granted to the authority to dispose of the application of the petitioner in accordance with law.
And install new meter within 2 weeks. Not only dispose of the application. Please see the application. It says that new electric supply was sanctioned already. Right?
yes, ma'am.
No, Lordship. Not sanctioned.
So what is the difficulty in granting the electric connection?
Lordship, we have to see whether they are encroacher of forest land. If forest land, Lordship, as per Godavarman, we can't cut the trees and we can't do anything. So we have to take the report from the forest department whether the lands belong to forest department or not. That is the difficulty, Lordship.
What had been done before the sanction was granted? Where is the sanction order?
Sanction order is not there. Page number 36, my lord. There is a report
submitted by this authority, applicant submitted for her affidavit page with photocopy voter ID, ration card, and after self-inspected the premises, the service connection estimated. Further submitted all for NA placement. Again, it's submitted 25/7/2024.
Page 36 says that it is government land.
Government, yes, ma'am, yes,
So
ma'am.
let them dispose of the representation, your application.
Dispose
Lordship.
within a time frame.
Yes,
Wait.
within 2 weeks.
Okay, my lord. God bless my lord.
The I heard learned counsels for the parties. The petitioner seeks disposal of her application submitted before the respondent
Assistant engineer.
on submitted before the third respondent on 18th July 2023 for domestic electricity connection in her property. The application is yet to be considered by the authority. Paragraph in view of the above, this court directs the third respondent to consider and dispose of the application submitted by the petitioner dated 18th July 2023 within 2 weeks from the date of communication of this order upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Stop. The decision taken by the authority shall be communicated to the petitioner within 3 days thereafter.
Lordship.
God bless.
The petition being such and such is disposed of.
Obliged, Lordship.
Certified. Oh, please add that line since no affidavit is invited.
Lordship, Lordship.
Next.
Item number 7, WPA 344 of 2025.
My lord, I appear for the writ petition, my lord.
Lordship, I am appearing for the respondent, Lordship. I have received the report from the authority. Can it be fixed on Monday? I will place the report before this honorable court. This writ petitioner already having one electric connection in the encroached land.
No, my lord. We don't have.
I have the document. I will show that document.
Who are respondent numbers 2 and 3?
So number 2 and 3 are.
So you are appearing for all the respondents, right?
Lordship, I am appearing for all the respondent, Lordship. Let it be on Monday, Lordship. I will place this report before your Lordship. Monday or Tuesday, any day, Lordship.
The respondents are represented and seek to submit a report in this matter. Paragraph.
Already I have received the report, Lordship. I will place it before this honorable court.
Let the matter appear under the same heading on 5th August, Tuesday.
Lordship. Lordship. Obliged, Lordship.
Next.
Item number 8.
My lord, this is that matter, my lords, where my lord had called for a report from the registry, my lord. Item numbers.
To the appeals.
This was 8 and my lord may have 8 along with 11. Both these matters, my lord, it was our contention that appeal has been preferred in similar matter. But my lord, since the case status suggested that my lord, the appeal was numbered, yes, after your lordship's earlier order. So my lord had called for a report, my lord. My lord, our humble submission is when it was filed much earlier, but my lord, defects were cured later, which is why that the numbering was done on 14th of August.
4th July.
Yes, yes.
Yes.
So let these matters be placed before the next circuit. Or let them go out of list for the time being. Yes?
Well,
Appeals have been filed. Let them go out of list till the appeals are disposed. Similar issues, right? Yes. Report submitted by the learned registrar, circuit bench
yes,
of
sir.
Calcutta is taken on record. It appears that appeals have been preferred by the respondent authorities before this court. pertaining to similar issues as in the present application. Paragraph in view of the above, comma, the application is, let the application go out of list for the time being.
8 and 11.
8 and 11, same one.
Okay.
Yes, sir.
Item number 9. WPA 30/2024 with item number 10.
This matter has come before your lordship because of the deletion application, my lord. There is an application for withdrawal by one of the petitioners.
The can has come today.
Yes. My lord, the writ petition number 3 in item number 10 want to be withdraw her case, my lord. We have specifically prayed that her name will be deleted from the.
Can 1 of 2025 in WPA 314 of 2024.
There is some problem. Yes,
Yes.
because in the condition she will not press this application because she has not been selected. Just now, your lordship.
The writ petition,
She will continue with the restriction. She will not press this.
the
withdrawal application.
can she not, very well. So are you ready for the hearing of the writ petition?
Monday, actually.
But if taken one. My lord?
Monday. For you.
Can is being not pressed.
Yes, ma'am. No, not press meaning they want to go ahead with the matter.
Yes, they want to continue with the writ petition.
So, my lord, then my lord, the matter may be fixed on a date, my lord, for hearing. Because today it was listed for that purpose, my lord.
I am not pressing for hearing.
No, then let it go to the next circuit in that case, my lord.
Let it be on Monday, your lordship. Very short point is there. These are contractual employees. Whether
A lot of matters, my lord, one day.
by another set of contractual employees. That is the only point.
The
Yes.
vacancy notice specified the age limit, my lord. It was in terms of the rules. They have not challenged the rules. And they are seeking a declaration that the requirement under the vacancy notice is to be ignored. But that is on the merits, my lords. I'm not saying that. If, my lord, I have no difficulty if Ms. Nag wants there is some urgency at their end, then my lord may fix it whenever, my lord. I'm not saying that.
Your lordship, I am insisting for the hearing for last many circuits.
No, it was argued also last time, then it was adjourned at your request.
But due to some reasons, your lordship, it could not be
If it's
concluded.
a longish matter, I don't think
It
next
is-
week it will be possible.
It's
That's
not, your
why.
lordship. I am submitting only this point is there.
Yes, Mr. Chakraborty, short matter.
Oh, what, my lord, I have no difficulty. Let it come on Monday, Tuesday, Wednesday, my lord. Let it come on Wednesday.
Wednesday, very well, let us see. The application being can one.
Or my lord, let it come on Thursday, my lord. Thursday.
Very well. State cannot be done. Let it appear, let us see if we have lesser matters, let us see.
Let it be on Wednesday, your lordship. Let us try. If it is not possible, let it be
Wednesday, I have some difficulty, my lord. That is why I'm requesting for Thursday, my lord.
Tuesday.
Monday, Tuesday, there are several matters.
Then Thursday, your lordship. Let it be on Thursday. Let it
Thursday.
possible, your
The
lordship.
application being can 1 of 2025 is not pressed. Not pressed by the third respondent in WPA 314 of 2024. Paragraph in view of the above, comma, the application is dismissed as not pressed. Paragraph, the writ petitions shall appear under the same heading on 7th, Thursday 7th.
7.
Most grateful.
Obliged.
So over. Mhm. There's a 12 o'clock specially fixed matter. Who's appearing for the state in this? Yes, are you ready? Because my list is over. Have you served the state?
Yes, we have served the state. We have served them on WhatsApp also. WhatsApp. Check what we are doing.
On Monday.
We request not cease from Delhi. I am from Bangalore. We are only seeking for some interim protection from them. Where he's for the de facto.
My lords, may kindly record that we have been offered a settlement by the petitioner.
Till then, what we are responsible. Like some protection.
That's very important. We have to bring the MOU on record, my lord. It's not yet been signed. We'll bring it on record and meanwhile,
Find an application to that effect, right?
they have not.
Verbal submission.
That's our verbal submission. That's his submission. He has
He's not-
offered us.
He is there for the de facto complainant.
Yes.
If in case he makes that submission, my lords, your lordships may consider is what my only prayer is. Till next week.
You're on bail.
No, my lords. My lords, I have arrived in the Port Blair on 25th. I am coordinating for the investigation from that time. Not been arrested. It is a civil dispute, basically. Now, please, my lords, he has come forward to settle the dispute. I'm asking only for the interim
date-
protection.
That is here. I don't think I can give you a interim relief. Come back on Monday.
My lords, what I'm asking, my lords, some interim protection till that time, my lords, because I am here voluntarily. From that day, my lords, other petition was,
Then you've not been arrested, you're cooperating.
my
So you
lords,
require an interim
it is,
protection
it
for
is,
today,
it is not going in direct.
day after tomorrow.
My lords, some protection, my lords, because the de facto complainant himself, I'll make him to submit if in case.
It's not, and cannot be done.
My lords,
I need to hear the state before any order is passed.
I send agreement with.
There
the
are
lordship.
questions of connivance. You are aware of the other aspects. I don't want to go into that now at this
Yes, my lords,
stage.
yes.
I need to hear the state before any order is passed. Come back on Monday.
my lords, some interim protection is what I'm, not to pass, take any coercive step, my lords, that's what I'm pleading. If
But at
only
least
because
we
these
can
are-
record it, that, the petitioner offering us a settlement and the price and the file is presented today. And we'll place the MOU on record. Let the MOU come on record at the first chance, my lordship.
Learned counsels for the petitioner and the private opposite party submit that the petitioner has offered a settlement of the issue between the parties and a memorandum of understanding has been prepared to that effect.
It's been prepared, but it shall be placed on record, my lords, because there are foreign clients, they'll have to fly down from Iran.
Be placed on record in due time. Paragraph, the state is not represented. The official respondents are not represented. Paragraph, let the matter appear under the same heading.
we have served, my lords, that may be known. We have served the office of the
Yes.
public prosecutor.
Will you come back on Monday?
My lord, my lordship, my difficulty is till Monday, Tuesday and Wednesday. It could be Thursday or Friday, my lordship. Subject to
Thursday in that.
Thursday, my lordship. My lord, just one request, and that my colleague is agreeing to it. If meanwhile the passports may be deposited, my lordship, and he is agreeing to it. It's not the case that he's not agreed to it, because it's a question of $50 million, my lords, on board. And
lords,
the stake of the foreign clients are at stake.
My humble submission before your lordships is, I'm at your, I'm at to,
There will be no coercive steps till the adjourned date.
please, my lords, that's
Right.
what I'm seeking some protection. my
But
lords.
subject to the deposition of the passports.
I'll do it right away.
Yes.
Appear under the same heading on 7th August 2025. Paragraph, the petitioner agrees to deposit his passport for this court,
Please, my lords,
before this court in course of the day.
right
In
now.
course of the day. Paragraph. No coercive steps be taken against the petitioner with regard to the present matter till the adjourned date, subject to his depositing his passport before this court.
And bringing the MOU and record, my lords, and bringing the MOU and record. That's very important. They shouldn't back out now.
There's no signature, no.
No, we'll bring it now and bringing the MOU and record, my lords. Till next day,
They face consequences.
Yes,
my
You
lords,
that-
my lords,
have at the moment nothing to lose
Lord.
in view of this order.
lordship.
Please come back.
Absolutely, my lords. My lords, may I seek for the hand delivery of the order, my lords? Because of the reason.
Immediately.
I'm so deeply grateful, my lord.
Obliged, my lord, obliged.
Much obliged.
You'll get it in the shortest possible time.
And we'll bring the MOU and record meanwhile.
I've recorded that.
Deeply grateful.